Dealing with the matter of opinion on the application of JB Garner and the Secretary of State for the Home Department.
Yes.
Good morning, my lords. I'm Lisa Giovanetti, King's Counsel, and I appear with Mr. Colin Coman on behalf of the Secretary of State. We're the appellants, and I appreciate it's unusual for us to be on this side of the court, but I don't know if your clerks...
Shall we call the parties the Home Secretary and JB? Because, like you, I get confused.
Yes. Thank you very much, Lord. And so Mr. Chris Butler of King's Counsel appears with Ms. Aisha Christie for JB. My lords, could I start with just general housekeeping?
Yes.
Check we've all got the same bundles. So in terms of materials, the court will, I hope, have a core bundle and a supplementary bundle. The core bundle runs to 259 pages.
Yes.
And the supplementary bundle runs to 341 pages.
332 electronically, but if anything arises on the last 9 pages, we can meet that when we come to it.
Are they missing?
Well, if I can firstly thank those who did the electronic bundles, because they have the same numbering as the paper bundles, which is excellent. But mine in the supplementary bundle runs out at 332. I'm just alerting you to that in case it should ever matter.
Ah.
So,
Don't worry about it now, Mr.
No.
If needs be, we'll
Mr. Toman can sort us out if that ever happens.
Thank you, Lords. Then we should have one bundle of authorities, which runs to tab 21, and a short bundle of supplementary authorities, 5 tabs produced by JB's team. You'll have seen that also JB's team produced a supplementary note,
Yes.
which I have loose, and I hope the courts also have our response, which is
Yes.
even shorter. The additional, I hope it's self-explanatory, but 3 versions of the statutory guidance, version 1, version 1.01 and version 1.2, we thought actually it would be helpful for you to have all of them. So we suggested that the version 1 produced by JB should be added to the end of the core bundle. I've done that in mine and numbered it 260 to 263. But wherever my lords have it, as long as it's convenient to hand. So, could I just start by outlining the scheme that I propose to adopt for my submissions? They fall into 4 parts. Firstly, and very briefly, I'll address the scope of the appeal. Secondly, I'll move on to the context of the appeal, and under that heading, I will outline briefly the scheme for asylum support and then the scheme of support for victims of trafficking. Third part of my submissions, I'll move on to the pandemic and its effect on the guidance and the facts of the case. And then fourthly, submissions proper, where I'll cover the law on interpreting guidance, the application of that to the provisions here, and what we say were the errors made by the judge at first instance.
Yes.
Subject to additional questions from the court, Mr. Butler and I had discussed timetabling. I anticipate that I should be comfortably finished before lunch, which he anticipates will give him ample time for his submissions and a reply. I hope that all sounds satisfactory.
Yes. We famous last words, but we thought it would be quite surprising if the argument required all day, but let's see how we go.
I was hoping that would be the case as well.
Yes.
So, to start with the scope of the appeal, it's just a little bit complicated in this case because, as you'll have seen, There were 2 orders at first instance, and so there are 2 separate grants of permission to appeal.
It's really one case, isn't it?
It is really one case, and that's the point I was going to make.
Yes.
Because the substance of the appeal is the appeal against the declaration. That's core bundle page 99, the order.
I'm sorry, the page number again?
Core bundle page 99
Thank you.
is the order at first instance. And for those of you who are working from paper copies like me, the declaration is just below the bottom hole punch.
Yes.
I won't read it out. I'm proceeding on the basis my lords have all had a chance to read through the Scottish arguments.
Yes.
It's very helpful indeed. The only thing I'd point out about the form of the declaration is that it's specifically limited to the context of a person receiving financial support under Section 95 of the Immigration and Asylum Act. There was some debate before the judge as to whether it should go wider and address Sections 98 and Section 4 as well. Those acting for the Secretary of State, which by that point included me on relief, said no, it should be limited to Section 95 because that's what he'd been addressed at first instance. And in the end, he plumped for that.
What follows from that restriction, if anything, so far as we're concerned?
I suppose what follows from it really is that there may be different considerations that apply in respect to Section 4 and Section 98. So for Section 4, for example, there's no power to provide money, cash benefits. And so that can be more complicated when one looks at the guidance and how that could apply to Section 4. And I say this simply because I'm very aware that my learned friends provided a table in their supplementary note which looked at various changes to Section 4, which you'll have seen we say aren't uncontentious. But in any event, the court doesn't need to go there because this appeal is concerned with how the guidance is to be interpreted in Section 95 cases.
Right.
I'll come back and deal with that further in reply if the court would be assisted and if I have to do that. And then the grant of permission to appeal, I won't take you to it, but it's at core bundle page 4, and you'll see that permission was granted effectively on the entirety of our grounds. And those grounds are at core bundle, just for your note, pages 43 to 48. So moving on then to the context of the appeal and the 2 schemes. And if it helps, we won't need to go to the supplementary bundle, the supplementary authorities at all for my purposes for this part of the submissions. We'll want the authorities and the core bundle. So may I start with asylum support? I'm sure this will be familiar to the court, maybe some members more than others.
Mr. Giovanetti, I dare say you're going to come to this at least under context, but could I ask now, because we've all been wondering, how many people were in Mr. JB's position?
I'm not sure there's a figure in the evidence before the court, but I do have instructing solicitors behind me who I'm sure can assist with that if you're happy to take it from me on instructions.
Yes, could we? We'd just like some idea. One of us saw a figure of 1,600 somewhere, and then another of us saw a much lower figure.
Yeah.
We assume that Mr. JB's circumstances are not unique.
No, they certainly are.
But on the other hand, it's quite a niche class of applicant.
Yes, it is quite a niche class of applicant, but can I caveat that? Because one of the things that have arisen in the past, and you've seen that possibly from the authorities, is that there can be claims in reliance upon Articles 8 and 14, for example, saying that there's been unfair treatment of one cohort as opposed to another. And because it's a large part of our case that the result of the judge's judgment at first instance is that this particular cohort get almost twice as much by way of trafficking support as, for example, people who are in self-catered or fully catered victim support provided by the Salvation Army. The potential consequences might be, and I say that cautiously, might be wider than just this cohort. One would then have to see what impact the judge's judgment at first instance had on others who might say they were disadvantaged by comparison and unfairly so.
But the raw figures that, in rough terms, I think we'd be helped by are for PVOTs who are also asylum seekers or refugees and provided with fully catered accommodation. So that's I think the cohort, and the other piece of information is the period of time with which we're concerned. We know what JB's period of time is, but we need to know
if
what
it
the
helps,
policy
I can
covers.
assist on that last point, because the window is it's a self-contained one, because the guidance came into force in March, which pretty much, we'll look at this in due course, but coincided with the start of the pandemic and the change in the way things were done. And then the Secretary of State issued revised guidance in August, which...
So it overlaps almost exactly the 5 months of JB's case.
Yes. Yeah. Okay. Can you get a ballpark figure?
Definitely will. It may not be until towards the end of the morning, but I wonder, could I just briefly ask my instructing solicitors?
Somebody must know this. I mean,
I'm sure somebody.
Are we talking about dozens, hundreds, or thousands?
I know that that the papers indicate that trafficking victims or referrals were running at about 200 a week or a month. A month, I think.
These figures must be published, aren't they?
Oh, I'm sure they must, but I don't have anybody from the Home Office in court with me. I've got an instruction solicitor from the Government Legal Department. So might I ask him to leave court now and make a phone call so we can come back with an answer quickly?
Yes. Just like some idea. Mr. Butler, do you know the answer?
I don't, I'm afraid.
No, you don't. All right. All right.
Sorry, I should have asked.
Carry on, Mr. Abernethy.
So the scheme for asylum support. As my lords, I'm sure will be aware, the scheme is legislative. It's the power and the duty are contained in the Immigration and Asylum Act 1999, which you have at tab 1 of the authorities bundle.
Yes.
And the key provision for our purposes is section 95, an internal numbering in the authorities bundle. At the bottom of the page, it's like small numbers. It's page 11. And section 95 provides materially that the Secretary of State will provide or arrange for the provision of support for A, asylum seekers, ... who appear to the Secretary of State to be destitute or to be likely to become destitute within such period as may be prescribed. The prescribed period is 14 days. Then subsection 3 defines destitution, and importantly, there are 2 limbs to it. So under 3A, a person is destitute if he doesn't have adequate accommodation or any means of obtaining it, whether or not his other essential living needs are met. And a person is also destitute under B if he has adequate accommodation or the means of obtaining it, but he can't meet his other essential living needs. And then I don't think for our purposes we need to look at the other subsections apart from 12, which records that Schedule 8 gives the Secretary of State power to make regulations supplementing this section. For completeness, at page 19 of that tab, my lords will find section 98, as it was at the time, and that provides provided and still provides for temporary support. I think the change that was made in June 2022 was to introduce into the section people whose asylum claims have been determined to be inadmissible under the new regime, but it doesn't need to concern the court. It's not material for our purposes. So by section 98, the Secretary of State may provide or arrange for the provision of support for asylum seekers, which appears to the Secretary of State may be destitute, but by subsection 2, that only applies until the Secretary of State is able to determine whether they're eligible for section 95 support. And then finally, because we've mentioned it and because I think Mr. Butler may want to take you to it in due course, section 4, which is again within the same tab, at internal page 3, we have the end of the process. So section 98 is while the assessment's being carried out. Section 95 is the main provision. Page 3 gives the Secretary of State power to provide or arrange for the provision of facilities for the accommodation of a person if he was but is no longer an asylum seeker. And again, that was amended in June 2022 in a similar way to section 98. The regulations which have been made under Schedule 8 are also in the authorities bundle, and you'll find those at tab 2. The key one for our purposes is Regulation 10, which is internal page numbering 44. And this regulation applies where the Secretary of State has decided that asylum support should be provided in respect of essential living needs. Subsection 2, as a general rule, and this is referred to in submissions, written submissions as the general rule, asylum support in respect of the essential living needs of that person may be expected to be provided weekly in the form of a cash payment of £40.85. These are the regulations as currently in force. In terms of the previous sums that have been payable, they're in the agreed chronology in the core bundle. You don't need to turn it up.
But if you just give us the 2020 figure.
Yeah. Okay, so prior to the pandemic, the figure was £37.75 a week. On the 15th of June 2020, it was increased to £39.60 a week.
Yes.
And the next increase was on the 22nd of February 2021 to £39.63. And then in February 2022, we moved to the current rate of £40.85. So it's been between £37.75 and £40.85 since early 2020. And by Regulation 10.5, you'll see that where the Secretary of State has decided that accommodation should be provided for a person by way of asylum support, and the accommodation is provided in a form which also meets other essential living needs, such as bed and breakfast or half or full board, the amount specified in paragraph 2 shall be treated as reduced accordingly. Now, the way this has worked in practice is very helpfully summarised by Mrs. Justice Farby in the case of JM, which you have in your authorities bundle at tab 20, and I wonder if we could turn that up. The report starts at internal numbering page 460. That's internal numbering of the authorities bundle at the bottom. In terms of the internal numbering of the report, that's 260 at the top of the page.
Sorry, Mr. Abernethy, I was behind you. Which number in the authorities bundle?
It's tab 20.
Yes.
And if we could pick it up at page 265, at paragraphs 11 onwards, she summarises the provisions we've just looked at. And then if we pick it up at paragraph 19, which is on the facing page, she summarises the effect of Regulation 10.5, and then towards the end of the fourth line down, she describes the practice. In practice, the prescribed cash amount represents the sum of several constituent elements which each represent an essential living need. For example, food, clothing, toiletries. If any one of these elements is provided in kind in the accommodation, for example, meals, the amount allocated to that element is deducted from the prescribed amount, and the asylum seeker's cash payment is accordingly reduced. An appropriate deduction will be made if an asylum seeker has income or assets. Then if we go over to page 269, she deals with asylum support in practice, and she's dealing in this section, that's paragraphs 31 to 34, to the position prior to the onset of the pandemic. And you see that from the subheading just above paragraph 35 at the bottom of that page, where subheading is the onset of the pandemic. She then goes on to examine and summarise what happened then. But for the moment, if we just look at the position as it stood prior to the pandemic, when the guidance was being drafted. So maybe start at paragraph 31. So that records that accommodation is procured by the defendant through arrangements with service companies known as accommodation providers, and take the form of detailed contractual terms, supplemented by a service delivery guide. The accommodation may be half-board, full-board or self-catering. Accommodation providers may procure sites for accommodation that could provide other essential living needs, such as hotels that are set up to provide full-board facilities. Prior to the pandemic, a person would be housed on a temporary basis under Section 98 in initial accommodation, which was typically a multi-person full-board hostel. Those housed in initial accommodation would not receive a cash payment from the Home Office for any essential living needs. The defendant's policy, not an issue in these proceedings, is that either those needs didn't arise on a short-term basis, or they could adequately be met by the full-board basis of the accommodation. Longer-term accommodation, for those eligible for Section 95 support, is sourced by accommodation providers from a stock of dispersal accommodation, reflecting the desirability in general of providing accommodation in areas in which there's a ready supply, which is a quote from Section 97(1)(b), and dispersal accommodation is generally self-catering accommodation in flats or houses. Someone in the claimant's position prior to the pandemic could typically expect to live in hostel accommodation for a short time without receiving any cash payments, and then be moved to self-catering accommodation with essential living needs met in cash through the operation of an electronic Aspen card, which is a type of debit card. It doesn't need to describe how that operates, and we don't need to be too concerned with that either. Now, in terms of what is a short period, Mr. Butler makes the point it was not that short, and it's referred to as being generally around 4 to 6 weeks. But it's short in comparison to the position, as we'll come to see during the pandemic, when asylum seekers eligible for Section 95, so fully eligible for support, were spending lengthy periods of 10, 12 months in the initial full board accommodation. And can I also mention, draw attention to the last sentence of paragraph 34. Accommodation providers who give cash to those living in initial accommodation don't use the cards, they give actual cash or vouchers. Just for your note, in the supplementary bundle, at page 12, para 20, it's in the evidence, there's an example given. So some accommodation providers providing full board accommodation might not provide the sort of little toiletries one finds in hotels, but might give a small amount of cash so people go and buy their own shampoo or toothpaste or whatever. So even in initial full board hostel or hotel accommodation, there would occasionally be provided by the accommodation provider a modest amount of money instead of the full board that they were, an element of the full board, which included toiletries, that they were contractually obliged to provide. The system's also summarised by the judge at first instance, Call Bundle 112, para 26, largely in the same terms, but more abbreviated, and there's no issue, I think, with any of that. And I'll come in due course, if I may, to the changes that took effect at the start of the pandemic. So that is the scheme for asylum support. Could we turn then to the support for victims of trafficking, which includes potential victims of trafficking? Can I take it the court's familiar with the general NRM scheme, where somebody who presents or is referred, first of all, receives a reasonable grounds decision, at which point they're described in the authorities quite often as a PVOT, potential victim of trafficking. I'm going to try and avoid using the acronym because this case is plagued, I think, by too many acronyms. So I'll just call them all victims because they're in the same position for our purposes, people who've received the initial reasonable grounds decision and people who've received the final conclusive grounds decision, where I think it's common knowledge there's often a long period between the two. So I should just refer to them all as victims because for our purposes there is no material difference.
I should know, but I don't. Has JB himself been the subject of a conclusive decision?
No, he hasn't. At least he certainly hadn't at the time we agreed the chronology, and I think that's still the case, isn't it?
It's still the case. 2 years, 10 months.
Thank you.
So the period of time, I mean, I know from other cases that it is a long time. It's not. That's still the case. It's not getting any shorter.
No.
Large cohort of people are in the PVOT category.
As far as I'm aware, I remember doing a case in front of Mr. Justice Garnham a couple of years ago about the length of time that it took, and I've got no reason to believe that things have significantly changed since. I suspect that was before the pandemic. I suspect during the pandemic there weren't a huge throughput of detailed decisions, but I don't know. But it certainly is a substantial period of time and continues to be in JB's case.
Yes, right.
So the framework of support for victims of traffic is not enshrined in legislation, primary legislation and regulations. What there is a power under the Modern Slavery Act to issue guidance and trying to find a way to help the court with an overview of the scheme without moving from one document to another in a variety of bundles. It seemed to me that the best summary is once again in the case law. It's in the recent decision of this court in MD, which you have at tab 21 of the authorities bundle.
Yes.
It starts.
This is Lord Justice Underhill, is it?
Yes.
Yes.
It starts starts at internal numbering, page 494. And I wonder if we could pick it up at page 501. There's a heading next to the letter H, VOT support. That's VOT, an abbreviation for victims of trafficking. And he sets out the background, namely the European Convention on Action Against Trafficking, ECAT, at paragraph 19. And then at paragraph 20, the EU directive, often referred to as the Anti-Trafficking Directive, Directive 2011-36 EU, ECAT is also summarised, it's Article 12, which is the key article, at in our skeleton argument. That's at page 16 of the core bundle, just for your reference, I think in almost identical terms. And probably the key part of Article 12.1, well it is the part set out by Lord Justice Underhill at the very top of page 1190. Each party shall adopt such legislative or other measures as may be necessary to assist victims of trafficking in their physical, psychological and social recovery. Such assistance shall include, at least, standards of living capable of ensuring their subsistence through such measures as appropriate and secure accommodation, psychological and material assistance. At paragraph 21, Lord Justice Underhill records that the UK has sought to implement the relevant obligations, not through legislation, but by administrative policy. It records towards the second half of that paragraph that the arrangements were originally under a contract referred to as the Victim Care Contract, more recently as the Modern Slavery Victim Care Contract, a version of this contract having been in place since 2009, and the version with which the court was concerned, and indeed it's the same version with which this court is concerned, is that entered into in 2015. At 23, he records that initially there was no formal statement of policy, and at 24, he explains how the amounts of trafficking support were to be calculated under the contract in a table. And can I pick it up at line 5? It's the line that begins with the words user type. He says, we're concerned only with the third row of the table, which specifies the payments for service users accommodated by the authority and in receipt of subsistence payments through that service. The amount payable in such a case is £65 minus the amount of subsistence received by the authority.
This is the famous error where
Yes,
by must
instead
mean
of from. Yeah, precisely.
Yes.
The authority is a reference to the Secretary of State. Common ground that the reference to by is a slip for from. Even as corrected, the language is rather opaque, but it's not in dispute that the effect is to require the deduction of sums received under the asylum support regulations by victims of trafficking who had made asylum claims. Thus, a victim receiving asylum support would receive an essential living needs payment from the Home Office under Regulation 10.2, together with a top-up payment from the Salvation Army, who are the contractor for victim support, to bring the total to £65. We don't need to look at the figures for 2018, but we do need the last sentence of this paragraph. It is necessarily implicit in that approach that a subsistence payment under the VCC, the contract, is intended to cover more than essential living needs. As to this, see paragraph 27 below. And that's where we get to the heart of it. So could we jump to paragraph 27? 27, Lord Justice Underhill says this. I need to refer to an episode in March 2018 which cast light on the Secretary of State's obligations as regards subsistence payments. The effect from 1st of March, she reduced the amount payable from £65 to £37.75 on the basis she believed it was wrong that they should receive more than was received by asylum seekers for essential living needs. In the K case, Mr. Justice Mostyn held that reduction was unlawful because it was based on a misunderstanding of the concept of subsistence in the directive. And it's the same for ECAT, so where it says directive, you can read ECAT, to which the VCC was intended to give effect. In the context of the directive, the term subsistence went beyond the minimum required to stave off destitution, i.e. essential living needs, and also covered pecuniary assistance with the recovery needs which were peculiar to victims of trafficking. And the top-up in the subsistence payment reflected that element. So to summarise, asylum support takes the form of accommodation for those who are without accommodation, and subsistence for essential living needs for those who don't have any means to provide for those. We've seen that under the asylum support provisions in the legislation. So accommodation plus essential living needs. The essential living needs may be met in kind, they may be met by financial payment. But for somebody who's a victim of trafficking, there is an additional element to which they're entitled as a victim, which is a top-up to reflect their recovery needs. That was the position when the policy was contained in the contract. At paragraph 28, Lord Justice Underhill moves on to consider the guidance. On the 24th of March 2020, the Secretary of State issued statutory guidance under section 49(1) of the Modern Slavery Act 2015. Matters that have to be covered by that guidance include the arrangements for providing assistance support. And you'll see that it starts from the reasonable grounds decision to persons who there are reasonable grounds to believe may be victims of slavery or human trafficking, which is why I say for our purposes we don't need to distinguish between those in receipt of reasonable grounds or conclusive grounds. That aspect is covered in Annex F, detail of support available for adults in England and Wales. There have been many subsequent versions of the guidance. We're primarily concerned only with the very first version and its immediate successor, versions 1 and versions 1.01. And that's exactly the versions that this court is concerned with in this case. At paragraphs 29 to 33, Lord Justice Underhill summarises, that sets out and then discusses the effect of the key provisions. They are the ones that are in the bundle added at the end of the core bundle. This is version 1 he's looking at here. Could I ask the court, I'm happy to read them out, it's probably not sensible use of your time. Could I ask you just to read paragraphs 15.35 and the beginning of 15.36, so down to the bottom of that page.
Yeah.
And then the rates are set out on the top of the following page. £65 per week for those in self-catered VCC accommodation. That's accommodation provided under the victim care contract. £35 a week for those in catered VCC accommodation. £35 per week for those receiving outreach support in other accommodation. At 31, he makes the point again that the financial support provided for is intended not only to meet the essential living needs of victims, but also to assist more widely with their social, psychological and physical recovery, a phrase deriving from Article 12.1 of ECAT. He then moves on to paragraphs 15.37 to 38. Those are the paragraphs specifically directed at financial support for potential victims who are also receiving asylum support, so where there's an overlap between the two schemes. And again, could I ask you to read paragraph 15.37? I'm sure you've looked at it because it's the key paragraph for our purposes.
It is indeed, yes.
And then it effectively provides that for those overlap cases where the potential victim or victims also an asylum seeker or failed asylum seeker receiving financial support under sections 95, 98 or section 4, the individual will receive £65 per week made up of his payments from asylum support and a further payment from the VCC to take the total payment to £65 per week. At 33, he notes that those paragraphs correspond to the arrangements operating under the contract prior to the guidance, and then he continues specifically. Paragraph 15.37 sets out the top-up arrangement explained at paragraph 24 above. We're not concerned in this case with dependent children 15.38, although the court rules in that case. He then deals with version 1.01 at paragraphs 35 and onwards. It was in fact version 1.01 that was before the judge at first instance, which we've pointed out in our note. But we don't think there's any material difference. I'll wait to hear what Mr. Butler has to say about that. But Lord Justice Underhill sets out what the 3 points of distinction are at the first half of page 1194. So there, the outreach support amount is raised from £35 to £39.60. The other 2 changes relate to child dependence, not a question with which the court's concerned in this case. And then he says at the end of paragraph 35 that paragraphs 15.37 to 38 remain in identical terms.
So none of these 3 changes matter, as it seems to me.
No.
2 and 3 because they relate to children, and 1 because, by definition, we're talking about the total of £65.
Yeah, 1 is dealing with outreach, and it just simply lifts that up a couple of times. So I'll wait to hear if it said that there is some other material distinction, but I'm not aware of one, or I haven't picked it up. And then, for present purposes, the last passage I need to take you to, and it's an important one, is at paragraph 39 under the heading Summary. And it's at 2, and it's the point that I made earlier on when we were looking at paragraphs 24, etc. If the beneficiary is in receipt of asylum support, the amounts payable are adjusted accordingly. In the case of adults, this means that they receive only the top-up payment, which is intended to address recovery needs over and above their essential living needs. So that's the purpose of these provisions in the guidance. You could really say the purpose is twofold. It's to make sure that asylum seekers who are being supported under the asylum support system don't miss out on the top up to address their recovery needs. Also intended not to cover their essential living needs, it's a top-up payment.
This authority is obviously very helpful as a survey of the canvas on which the current dispute arises. But you're not, I think, seeking to derive any particular conclusions from the way in which Hill summarises matters, are you?
Well, I am relying on the fact that he points out that this is intended to be a top-up to redress recovery needs. I think it's self-evident from the scheme, but in my
well, exactly. But I mean, the court there was not concerned with the issue which we're here for today, because I mean, as it seems to me, the whole thing turns on in 1537 whether financial support means money or whether it just means support. Isn't that what you're here to argue about?
It is.
And that's not something that the court was considering in MD. So I just think that if you're going to be suggesting that that Lord Justice Underhill is shining a light on the question with which we're concerned, I need some persuading about that.
Maybe I will come back to it when we get to my sort of summary of my submissions. But in my respectful submission, there was an overlap between the issue that this court is considering and the issue that he was considering. And maybe that comes out most clearly. I was going to come to it later, but I'll just draw attention to it now. If we turn on to page 1206 of this judgment.
Internal.
Internal 518 for the authorities bundle. It's paragraph 82.
Could you, while you're dealing with this, just put in a sentence what was the issue in MD?
Well, I'm sure Mr. Butler will
Yes.
put it in a more comprehensive way than I do. But it was about whether child dependence should entitle somebody to receive twice the amount of support in relation to some means-tested benefits. Fair? Mr. Butler's not shaking his head, so if we turn to page 80, you'll see it was about whether the payment of dependent child trafficking support to those in receipt of mainstream benefits was an anomaly. And it's this section of the reasoning at pages internal 518 to 520 that I think casts light on the issue this court has to determine. At 82, he's setting out submissions for the claimant, and you'll see that the first submission was that victim support is not means tested. The only exception is adjustment for adult victims of trafficking who receive asylum seeker support. But that's a targeted provision aimed at a very specific instance of victims being paid twice to meet the same needs, subject to point 3 below. So that was a submission. Then at 83, at the bottom of the page, Mr. Justice Underhill concludes that Lord Justice Underhill, I'm so sorry, that Mr. Justice Kerr at first instance was entitled to place weight on the common sense proposition that the government was unlikely to wish to pay twice in respect to the same needs. That is the same, we'd say, common sense proposition that we advance in this appeal, that the government plainly, when you look at the schemes, did not intend to pay people's essential living needs twice over under both schemes. He carries on. The fourth line on that page. It's always been government policy to deduct receipts by way of asylum support for essential living needs from the subsistence payments made to victims of trafficking. That is self-evidently on the basis that part of the subsistence payment is intended to meet essential living needs, and victims should not receive that element twice. Council acknowledges this.
But
At 85,
characterised as a single targeted exception.
yes.
But Mr. Lord Justice doesn't accept that.
At 85, he says, second line, it remains reasonable to believe the government did not intend victims of trafficking in Group 3, and that was the group he was concerned with, to be paid twice for the essential living needs. It's all part of the reasoning that he adopts by reference to child-dependent victims. The key underlying principle is that the purpose of this policy was not to provide duplicate payments for essential living needs.
No, well, can I just make sure that I've understood what the MD case is about? There's a discrimination issue which doesn't arise in the present case, but the issue you've just been covering, if I got this right, is whether the Secretary of State has to pay not only dependent asylum seeker child support, but dependent victim of trafficking child support
Yes.
as well.
Yes.
And the court holds that these are two payments for almost cover almost identical phenomena, namely the fact that the adult applicant has dependent children, and so it really is paying twice. You say that there's an analogy with somebody who is on full board. Mr. Butler is going to say, well, that's as maybe, but it's not what paragraph 15.37 said.
Yes.
Have I got the issue?
Yes,
All right.
my Lord has, absolutely.
Yes, thank you. Okay, what else do we get from MD?
I think that's the main thing we get for
Yes.
my purposes. The purpose of the policy being to ensure people get their recovery needs met, but not to give them twice the amount of essential living needs payments. So I think that's all I'm going to say about the two schemes pre-pandemic. Could we now look to see what happened as a result of the pandemic?
Because you've crystallised it so clearly, what then would a victim, to use your expression, expect to receive that was over and above what a refugee or asylum seeker would expect to receive?
So those under Section 95 who pre-pandemic were in self-catering accommodation, generally, receiving accommodation plus a financial sum each week as defined in the asylum support regulations for their essential living needs, would expect to receive, it's absolutely right.
No, I wasn't talking about figures. I'm sorry. I just wanted to conceptualise, given that there is an additional element to being a victim,
Yes.
which is that you're not just concerned with subsistence, but also concerned with recovery.
Yes.
Under your case, what is the victim entitled to that the refugee is not?
So they're entitled to the £65 a week that victims who aren't asylum seekers get, minus the amount of support that they get for their essential living needs under the asylum scheme. So there are the £65 a week that's given to people who are just trafficking victims in self-catered accommodation comprises two elements. There are two elements within that £65. That £65 is intended to cover essential living needs plus the recovery top-up, if I can call it that, the additional amount for recovery needs. Those two combine to give you the £65 total. Somebody who is in receipt of asylum support in the normal way under Section 95 pre-pandemic, have their accommodation, and they would also be receiving an amount under the asylum support scheme, it's referred to as the NAS payment, for their essential living needs. That amount would be deducted from the £65 and they would get the difference as their recovery need top-up. So if we...
In what circumstances are victims or potential victims of trafficking not seeking asylum?
Oh, I mean, there are a number of examples given in the case law. So it might be somebody who does not have British citizenship or indefinite leave to remain, doesn't have settled status here, but isn't claiming to be somebody who has a well-founded fear of persecution in their own country. They may claim they were trafficked here, because of course you can be trafficked internally within the United Kingdom. So you have, for example, people who are the cockle pickers, for example, at Morecambe Bay. They may have come to the UK intending to be students, and they're trafficked from within the UK, let's say from London to Morecambe Bay. They would be a victim of trafficking. There's been quite a lot of coverage in the press over recent days of the fact that there are people who are just UK nationals. So, for example, the young people who are drawn into the county lines gangs, who fall in the definition of victims of trafficking, but are actually British citizens, so they wouldn't be an asylum seeker. So there are a number of disparate groups. Although it's fair to say, I think, we'll have the figures in a moment, I hope, that the overlap group is a large one, and that there is a significant number of people who are both asylum seekers and potential victims of trafficking. I'm referring to it as a trafficking claim because it's not a claim. People are referred under the national referral mechanism, so they may be identified by a Home Office interviewer or by the police if they present at a police station. They give an account of what's happened to them, and they are identified as a potential victim of trafficking, and then they're referred to the NRM for assessment.
It doesn't involve necessarily any crossing of borders.
It doesn't necessarily involve any crossing of borders, no.
Thank you.
I think that's probably uncontentious, isn't it? Trafficking doesn't.
It's uncontentious.
Thank you.
So I was just going to say that if we go back to the figures I gave you a little earlier, taken from footnote 1 to the agreed chronology, prior to the pandemic, the rate in regulation 10.2 of the asylum support regulations was £37.75. Somebody who was just an asylum seeker and there was no trafficking referral would get their accommodation plus £37.75 a week. Somebody who was an asylum seeker in the same accommodation receiving the same support of £37.75, who was also the subject of a reasonable grounds decision, would get the additional £22.25 on my maths to take the total up to £65.
27.
Sorry?
27.75.
27, is it?
Yeah.
27.25.
37 plus 22 doesn't get much over 60. So I think you've
No,
lost
of course
five.
not.
You've lost £5
£27
somewhere.
Well, just as well I don't actually work out the payments, isn't it? Yes. But that's the additional amount they'd get for recovery needs.
Yes.
I think it explains in the case law it may be more of a need to communicate with people for support, maybe travel to counselling appointments, whatever. They're modest amounts, but those are the amounts. So, the pandemic. Could we move on at that point to
Yes.
what happened during the pandemic?
Yes.
Could we take that first of all from the chronology, and then we'll go back to JM and see how Mrs. Justice Farby summarised it in more detail, explained it, because our chronology is really just recording these dates with a little narrative. So the chronology starts at page 8. You see the figures I've been referring to at footnote 1. Could we turn over to page 9? I'll cover these together, if I may, what happened in the pandemic for the moment, the pandemic generally, and what happened to JB, because they coincide very almost precisely, and it'll save going back to it. So, can we pick it up halfway through December 2000, halfway down the page between the two hole punches, there's an entry for the 17th of December 2019. In fact, we pick it up just before then, the 12th of December. You see that on the 12th of December, JB claimed asylum. On the 17th of December, he received a positive reasonable grounds trafficking decision, which triggered his entitlement to trafficking support. On the 23rd of December, he started receiving trafficking support at a rate of £35 a week. That's the outreach rate at the time, because he wasn't in accommodation under the victim care contract, neither self-catering nor fully catered. He was living with a friend, so he was eligible for the outreach payments, £35 a week. We move on to March 2020. He could no longer be accommodated by his friend and applied for asylum support. On the 24th of March, version 1 of the guidance was published.
That wasn't prompted by the pandemic.
No, it wasn't.
It just happened to coincide with the...
Yeah. I think it's been a long
time in
the
planning,
making.
yeah. Okay.
25th of March 2020, over on the next page, JB was provided with asylum support and accommodation under Section 98, pending an assessment of whether he was eligible for Section 95, and was put in catered asylum accommodation. 2 days later, the Immigration Minister announced a suspension on the eviction of asylum seekers from Section 95 accommodation due to the pandemic. On the 31st of March, JB was granted asylum support under Section 95. You see that happened pretty quickly. At the time, most individuals granted asylum support under Section 95 and housed in hotel accommodation were treated by the Secretary of State as being an initial accommodation and didn't receive a cash payment. You'll see that subsequently, Secretary of State determined such individuals should have received cash payments, initially of £3 a week. We'll come to that in due course because it was inherent to the decision in JM. And payments were backdated to the 31st of March. The entry in that respect, the October decision, is at page 12. It's the top entry of that page. So from the 27th of October, Secretary of State determined that asylum seekers housed in catered accommodation should get some cash payments under Regulation 10, £8 a week to cover the remaining essential living needs. You see the reasoning for Mrs. Justice Farby. Back payments at a rate of £3 from 27th of March to the 30th of June and £7.70 from the 1st of July to the 27th of October. Those are the key chronological dates for our purposes. If we can turn back to JM, which is at tab 20, you'll recall. We pick it up at 469, where we left it under the heading The Onset of the Pandemic. You get more of an explanation of the matters we've just looked at in terms of the general position.
I'm sorry, which paragraph number, Mr.
Sorry,
Chairman?
paragraph 35,
Yeah.
towards the bottom of page 469 of the authority summary.
Thank you.
So 23rd of March, we get COVID restrictions being introduced, paragraph 35. Paragraph 36, we get an explanation of the letter, which I referred you to in the chronology, from the Minister, announcing a suspension on the requirement on asylum seekers to leave Section 95 accommodation when they cease being entitled to it. And that's explained between letters A and C, at page 270. At paragraph 37, the judge recalls that the benefits of the decision plain. It reduced the risk of contagion by movement of people outside their homes. It reduced the risk of asylum seekers catching COVID-19 or spreading it. But the effect, we see, paragraphs 38 and onwards, those who would ordinarily, in fact, rather than reading it, I'll just summarise it in my own words, at the end of the pipeline, people who would have been leaving self-catered accommodation weren't leaving. So the self-catered accommodation, the court's probably familiar with this, became full. There was a complete logjam. So people coming into the system at the other end, at the beginning of the pipeline, so applying for asylum, presenting as destitute and needing accommodation and essential living needs support, were going into hotel accommodation, but there was nowhere to move them onto. They couldn't be moved onto self-catering in vast numbers. And the Secretary of State responded by taking on additional volumes of hotel accommodation. And the result was that people who would normally expect to spend maybe 4 weeks in Section 98 accommodation, hotel accommodation, full board accommodation, before going out to self-catering, a flat or shared house, and getting a cash payment, were spending months in full board accommodation. At paragraph 40, you see that being summarised. Section 95 supported asylum seekers remained in initial accommodation, which is, it's not a statutory term, initial accommodation, it's just the Home Office term for the full board hostel or hotel type accommodation. They remained in initial accommodation until a place was found in dispersal accommodation, i.e. self-catering accommodation. Then we referred in the chronology to the October 2020 decision to provide backdated payments. I imagine that you might be assisted by reading the whole of the calculation of essential living needs section from paragraphs 48 onwards. But I'm going to pick it up at paragraph 61, where you'll see essentially that there was a review. Paragraph 62, a submission went to the Secretary of State and the Minister recommending that they agree to implement a change in policy towards the top of page 475, so that individuals in accommodation where some services are provided in kind who've been assessed as eligible for support under Section 95 receive a small weekly cash payment. Agree that payment to these individuals is £8 a week. And then at 63, proposals for backdated cash payments were made, including a proposal for £3 a week from the 27th of March to 30th of June, representing the clothing need, £7.70 from the 1st of July, representing the clothing need £3, and the travel need £4.70. And there's a lot of debate in the case about the extent to which you would need travel costs during the pandemic. This court doesn't need to be concerned with that. The key point is that provision was made for cash payments even to those who were in full board accommodation. And JB was one of those who benefited.
Why does what happened after the 28th of August 2020 help us?
Because, and no issue was taken with this below, and I'm not proposing to take issue with it now, Mr. Butler's case, that what you look at is whether his client was entitled to a cash payment. And anybody who is entitled to a cash payment of any size falls within paragraph 15.37. So as well as the backdated £3 a week, JB and others in his position were also entitled to the difference between the amount they were receiving and the £65 a week.
Yeah.
Yes.
Well, I understand that, and
Sorry, I
he
know
has
this
to
answers the
accept
question.
that after the 28th of August, the entitlement wasn't there because 1537 was replaced
Yes.
by something else. But why do the subsequent decisions help us?
Well, just because that's the basis on which he became eligible for a cash asylum support payment. Because JB was in fully catered accommodation,
Yes.
which ordinarily, although he was a Section 95 case, would not carry with it any payment of financial support.
This particular 5-month period with which we're concerned has happened purely as a result of the lockdown.
Yes. And at the
It's not it doesn't really seem to me to give rise to any great point of principle. But what's happened is that a policy was drafted without regard to the lockdown,
yes,
where people were going to go swiftly through hotel accommodation and then out into more or less catered accommodation in the community. But people like JB, unforeseen at the time the policy was drafted, ended up being trapped like everybody else was. So the circumstance in which we're being asked to interpret and depart from the words of your policy are really highly specific.
they are. And it's key to our case that in interpreting the policy, you look at the situation and the context that it was addressing. And you're absolutely right, of course, Maud. It was not addressing a situation where some people would be given a small cash payment, as we see happened, as a result of the pandemic. It wasn't intended to make them eligible to recover not only the recovery top-up element of victim support, but also a substantial additional amount, almost double that was being received by those in
Yes, but I mean, one can look at this obviously in two ways. The other way of looking at it is that you had a policy that you hadn't foreseen and nobody else had, the pandemic. And then it turns out that the policy doesn't work very well in the pandemic. But the question on the appeal is whether that's any good reason for not holding you to your policy.
Well, that's precisely the way Mr. Butler would put it, absolutely. And of course, Maud was quite right. Those are the two positions on this appeal. That is the crux of the question.
You're going to invite us to interpret the words of the policy having regard to the context.
And the purpose, yes.
And the purpose. And are you saying that the fact that the context changed because of the pandemic affects the interpretation of the words?
I'm saying that the purpose remained the same, to ensure that people got their recovery needs covered, but didn't get twice the amount of, or didn't get an overlap, get double recovery of essential living needs. That was the purpose. When the factual context changed, so the reference to financial support actually ended up covering a much wider pool of people and could have resulted in people getting twice the amount of essential living needs. That was not the intention of the policy, and the policy shouldn't be interpreted in that way. You say it did not cover this specific situation.
The words, you say, you must say this much, the words must be interpreted as meaning the same thing before and after the start of the pandemic. They can't mean different things at different stages of
No,
the pandemic, can they?
no.
Your point is the anomaly, or whatever you want to call it, only became more acutely apparent because of the pandemic, because the sums involved got substantially, well, relatively substantially greater.
Yeah, I'd say that in general there wasn't an anomaly pre-pandemic because of how the system worked in practice. So I think where I'd put it is there was a lacuna in the policy because it did not expressly make provision for people who received a small cash payment of this sort, and it certainly didn't envisage that as well as the £3 that it was decided to give them, they should get an additional £30 out of the victim support sort of pool of money.
This is why I still don't understand why you say that the decisions that were made in September, October 2020.
I'm so sorry, I didn't quite catch the end of that.
The decisions which were made by the Home Secretary or Home Office officials in September, October 2020 to make some extremely limited cash payments retrospectively, why they affect anything. Surely the question for somebody, in the case of somebody like JB, is straight away in week 1, 24th of March onwards, what is he entitled to? And then again the next week, the next week, the next week, and his circumstances don't change.
Well, that is how we say it operates. It's Mr. Butler's case that when it was decided that people should be given a retrospective payment of £3 a week intended to address what their needs would have been some months earlier, that carried with it an entitlement to also have backdated higher payments of victim support amounts from that date.
But it's nothing to do with retrospective payments. I mean, the retrospective payment was simply to make up for something that ought to have been paid in the first place.
Well, that's precisely how Mr. Butler puts it, yes.
But isn't that the case? I mean, the fact that it was mopped up in October at whatever level is irrelevant. If it was mopped up in October, it ought to have been paid in March. The question is what ought to have been paid in March, and the fact that, well, I mean, the way that you put it, which is that he's asking for a retrospective payment of £65, is rather a backwards way of putting it. The question is, what was he entitled to in March?
Yes. No, well, I'm perfectly happy to take it that way. I mean, as I say, there was no issue taken below with the fact that this was the £3 a week from March was the result of a decision in October, but I'm just trying to explain to you how it happened chronologically and in fact, so that our chronology makes sense. In fact, the issue is whether becoming entitled to the additional £3 carried with it an entitlement to some 10 times that amount from the victim support fund. We say the recovery need was the same. The recovery need didn't change because of the additional £3 of essential living needs, and that wasn't the intention of the policy.
Was there evidence about whether the recovery need changed during the pandemic?
Well, recovery...
Or was that's never been considered?
It's never been suggested. The recovery element paid to people who weren't asylum seekers in receipt of asylum support remained the same, apart from the uplift from £35 to £39.60 for those in outreach. But the £65 headline figure remained the same. The suggestion isn't there was an increase in recovery needs and therefore an increased payment. This is the issue here, I think, is quite plainly whether at the end of the day the £3 additional amount should have carried with it, because of the interpretation of the policy, an entitlement to a far greater sum by way of payment for recovery needs. And we say that plainly was not the purpose of the policy. It's
are we going to look at some stage at the frequently asked questions document?
We can do, yes.
Before
Could we just
go on to cases about interpretation, that's one thing we haven't looked at.
So that's in the supplementary bundle at tab 26, pages 305 to 6.
I think we were told in the chronology this was originally issued in January 2020 and then it was reissued later.
Yeah. And this was a document that went to accommodation providers, so effectively the Salvation Army.
On the 6th of April.
Yes.
So these were the questions that were being asked frequently on the 6th of April 2020. Is that right?
29th
Yeah.
of January.
So if it matters, pre-pandemic questions.
Yes, and just after the start.
What is the status of this document?
Document the claimant relied upon to support their interpretation of the policy.
And
Well, there's also the victim care contract itself between the Home Office and Salvation Army.
That's
Both
right.
things have been referred to.
Yes.
We probably ought to look at both of them, or it doesn't matter in which order.
should we start? And these who publishes this? You publish these.
The Home Office sent this to accommodation providers, as I understand it, I'm sure I'll be corrected if I'm wrong, to address some questions that were being
Yes.
put forward on a regular basis by accommodation.
And is it? Should we regard it as on the same status as other guidance? And if not, why not?
Well, it certainly hasn't got the same status as statutory guidance issued under the statute in a formal sense, but it's to be interpreted in the same way we'd say, in a common sense way, looking at the purpose and what was it the intended meaning. So, not interpreted by the statute.
Isn't the format of frequently asked questions a common way in which guidance is given in what's perceived to be a user-friendly fashion?
Yes, yeah. So, yeah, and it's not statutory guidance, but it is guidance. I mean, I was going to make submissions in due course, but I think they're probably pretty self-evident, and so I'll just make them now. But we're not looking at a statute that's been drafted by Parliamentary Council, debated line by line within Parliament. So one's got to take into account the context in which it's issued. But yes, it is guidance.
And it's good. I didn't know anything about any of this until I read the papers in this case. But this is not just a FAQs document to be issued to CABs or welfare advisors. That the Salvation Army were the Home Office's agents in providing support throughout England. So this is quite a significant document, as it seems to me.
Yes.
All right, let's have a look at it.
I think one point to be made about it is that a lot of the terminology in it is lifted from terminology in the guidance. So
Yes.
accommodation clients would ordinarily mean people being accommodated by the Salvation Army, because we've seen that the statutory guidance refers to them in those terms. So there are ambiguities in this. But anyway, are we correct in understanding that accommodation clients are entitled to and should get £65 per week subsistence, regardless of benefits or income from work, etc.? Well, we know that there's no issue, but that the victim support payments aren't means tested, and you just disregard state benefits, ordinary mainstream welfare benefits.
Yes.
The answer is yes, unless they're receiving support from the asylum support system, in which case their financial support should be £65 per week minus the NAS payment.
Yes.
Subsistence for catered accommodation clients. Are we correct in understanding that catered accommodation clients, so plainly accommodation clients in the first one doesn't mean catered accommodation clients, it means self-catering accommodation clients, because catered accommodation clients is dealt with separately under question 2. Are we correct in understanding that catered accommodation clients are entitled to and should get £35 per week, regardless of benefits or income from work, etc.? Yes, unless they're receiving support from the asylum support system, in which case their financial support should be £65 per week minus the NAS payment. The continual thread you get is asylum support is to be deducted from the amount paid under victim support.
What is the, could you just tell us again, what is the term of art, the NAS payment, to be understood as?
National Asylum Support System.
Yes, I understand what the acronym is, but
I'm so sorry, my lord.
what's the NAS payment?
Well, that's the issue at the heart of this case.
Well, exactly, but it's your case that the NAS payment doesn't mean a payment at all, that it can be used to encompass any form of support, such as a room.
No, my lord, it isn't. It's not accommodation. It's essential living needs support.
Right, so the NAS payment is, deconstruct it so that it isn't used as a term of art.
Well, the NAS payment means essential living needs support.
In cash.
Well, it says payment, so
Payment.
Yes.
On a literal meaning, yes, that is what it means. But that's got to be seen in a context where, for people receiving Section 95 support prior to the pandemic, they would receive all their essential living support by a cash payment. So really what was being looked at by the Home Office were two cohorts of people. People who were in fully catered accommodation and people who received their essential living support in cash because they'd been moved on to self-catering.
Is the phrase the NAS payment defined anywhere?
No.
But
The closest one gets to it is 15.37 in the statutory guidance, which we've looked at, which it might be helpful to go back to at this stage, because...
Yes, but before we leave this talk, question 2 is exactly Mr. JB's case, isn't it? He's a catered accommodation client.
No, not... Mr. Butler says he's number 4, outreach NAS clients. That's why I say you've got to be careful about this, because this is much less formally worded than the statutory guidance.
But all the first 4 questions, the answer given is the same. You get £65 a week less the payment, if any, made under the NAS scheme.
But if we look just as a starting point, as the context for these FAQs at the statutory guidance version 1, we might do that, because I just think it may help you with accommodation clients and catered accommodation clients. same on the MSVCC. So Mr. Butler makes the point that this predates the statutory guidance. This is at the time of the victim care contract. I think the language is the same for both.
But the phrase minus the NAS payment appears in the answers to the first three questions and as part of question 4A. There doesn't seem to be a 4B. But I suppose this is regarded.
Anyway, it's 4.
This is, we're then asking frequently asked questions about frequently asked questions. This is aimed at the contract providers. This document.
Yes, it's aimed at the contract providers.
Who are the payers? Who are the payers?
Yes. All I'm saying is that the language of accommodation clients and catered accommodation clients in 1 and 2 has got to be seen in the context of the other questions that are asked, because that's looking, I think, at clients who are accommodated by the Salvation Army.
The NAS payment must mean the same thing, mustn't it, in all three questions and all three answers to the first three questions and the fourth question?
I think what this is trying to make sure is that whoever is accommodating the person concerned, whether it's the Salvation Army, whether it's asylum accommodation, that they don't receive double the financial payment. That's the minus the NAS payment throughout. And as Mr. Butler says, this was pre-pandemic, where the general situation applied. So people who were being provided with support under the NAS scheme would generally, as Mrs. Justice Farby explained, either be in their initial short-term fully catered accommodation, no NAS payment, or would be in self-catering accommodation where their essential living needs were met by the, let's get the figure right, £37.75 a week essential living payment.
Well, could we forget the pandemic for a moment and assume that JB had moved on within 4 weeks?
Yes.
Would he have been entitled? What would he have been entitled to during those 4 weeks?
The initial 4 weeks.
Yes.
I think on everybody's case, on an ordinary pre-pandemic basis, he would have got his accommodation on a fully catered basis from under the asylum support scheme. So he wouldn't have been getting any NAS payment at all. So he wouldn't fall within 15.37. People were getting £35 a week, which was the outreach payment amount. Also the amount that was being paid to the people who were in fully catered accommodation under the victim care contract.
And so which of these FAQs would he have come under? Wouldn't he be number 2?
Not entirely clear which he'd have come under, but he would have been getting £35 a week. We know he was getting £35 a week. We know that others in his position were getting £35 a week. That's correct, isn't it? Mr. Toman also confirms that he wouldn't have been a catered accommodation client under 2, because that's talking about catered accommodation clients of the contractor. So those who the Salvation Army are accommodating in fully catered accommodation.
Mr. Butler says it's under 4.
Yes.
Yeah. Well, I think we're probably both in agreement that it's not under 1 or 2.
Right.
Thank you.
I don't know how much time we're going to spend analysing this document, which we're having trouble with. But under 4A, the phrase, as I've already observed, minus the NAS payment,
Yes.
appears in the question,
Yes.
not in the answer.
No.
But the words that appear in the three answers above it, before the NAS payment, don't appear. But should we read into 4A the words, unless they are receiving support from the asylum support system, in which case their financial support should be X minus the NAS payment?
Unless they're receiving asylum support, essential living needs support, in which case, yes. The answer to 4 is this should be the position for all clients who are also receiving financial support from NAS. And I think it's common ground that he would not have been receiving financial support from NAS under the pre-pandemic system for the initial 4 weeks in fully catered accommodation.
That's not common ground.
Common ground. I'll let Mr. Butler make a submission. But we say Mrs. Justice Bobby was entirely right when she said the Secretary of State's position pre-pandemic was people should spend 4 weeks or so, might be a little less in some cases, longer in others, but 4 weeks put to me, in initial accommodation which was fully catered, a hostel or a hotel, at which point they received no payments because everything was expected to be provided for them. They would then move to self-catered accommodation, at which point they'd start receiving £37.75 is the figure. It's not plucked out of the air at 4A. E.g., if the client receiving £37.75 from NAF, they're only entitled to the £27.25 top-up from the VCC, regardless of any other income. This should be the position for all clients who are also receiving financial support from NAF, i.e. the people in self-catered accommodation who receive the £37.75 a week. Regardless of where they're accommodated, any other income should be declared to the asylum support system. It's not the clearest, I accept.
No, it's not. The other document which we haven't looked at, and perhaps we should, is the table in the contract between the Salvation Army and the Home Office. It's at the very end of the core bundle. Now that I've found it, it's about contract relating to the supply of services to adult victims of modern slavery. In the very last page of the bundle is a table which I think I've seen somewhere else in Skeleton Arguments. And I think this, I don't know what the date of this page is, this version, but it seems to be what's applicable. And which...
I think it's page 248
That's
of the core
it.
bundle.
That's the one.
And that's the one that has the by when it should have been from.
Oh, yes, yeah. But it's the third type. JB was service user accommodated by the authority.
Yeah.
That's the Home Office, not the Salvation Army.
Yeah.
And in receipt of subsistence payments through that service,
Yes.
value of subsistence payment, £65 minus the amount of subsistence received from the authority.
Yes, but this only applies to a service user who is A, accommodated under the asylum support system, and B, is receiving subsistence in the form of payments through that service. So, as we saw, the position pre-pandemic, and this is a pre-pandemic document, was that those in initial accommodation weren't in receipt of subsistence payments through that service. So in the ordinary case, pre-pandemic, somebody in the initial accommodation, full board, fully catered, before the decision in October 2020 to give a small amount, was a service user accommodated by the authority, but not a service user in receipt of subsistence payments through that service. And there may have been the odd exception. Mr. Butley will take you to one example, but that was somebody who couldn't eat the food that was being provided in the fully catered. It was quite exceptional.
Yes.
The general position was, as recorded by Mrs. Justice Farby, no cash payments in the initial accommodation. And that's why there was the controversy within the Home Office about whether, because people were staying there for a long time because of the pandemic, they should receive a modest cash payment as well as the full board accommodation.
Is the phrase subsistence received by, brackets, from, close brackets, the authority, defined?
No, it isn't. But we see under the first column, service user type, accommodated by and in receipt of subsistence payments through that service. So that's why I say there was a lacuna, because what none of this envisaged was that people in the initial fully catered accommodation would start being paid £3 a week because of the unusual circumstances of the pandemic, which meant they were staying there for much longer.
Which category on page 248 do you say JB fell into at the end of March 2020?
He didn't fall into any of them.
I don't understand.
Yes.
And what actually happened in practice was that people in JB's position were given the same amount of payment as was received by both the outreach cohort and the people who were in fully catered Salvation Army accommodation, i.e. initially £35 and then £37.
I think my Lord's asking, if we ignore the right-hand column, which category did they fall into?
Yes.
He must have fallen into one of the four.
No, I mean, he didn't.
Or is he a service user? Yes. Is he how do you define him then? Just ignore the right hand, ignore the column value of subsistence payment. Just look at service user type.
Yes.
So he's a service user.
He is a service
So,
user.
but he must fall into one of those categories, mustn't he?
Well,
If not, how would you define him?
not if there is a lacuna in the policy and the guidance.
Well, how would you define what he was then? In terms of make the sense of this document.
He was a service user accommodated by the authority and not in receipt of subsistence payments through the service. He doesn't fall within, and that is our ground of appeal, and that's our skeleton argument, that there was a lacuna and the policy and the guidance did not make express provision for people who were in fully catered accommodation, presumably on the basis that it was intended to be a very short-term situation. It was never intended to be something that went on, and it wasn't in practice.
How can that be right? I didn't understand your case. I mean, this is a document which defines service user as a potential victim of trafficking that has entered the service.
Yes.
So the instruction to the Salvation Army contained in this document says, page 248, the contractor, that's the Salvation Army,
Yes.
shall provide service users with subsistence payments in cash.
Yes.
And these should be provided weekly and so on. Well, but you're saying that the service users of a particular type shall not be provided with anything.
I'm saying that the contract didn't provide expressly for them to be provided with anything. I think probably because it was envisaged that that nobody would be in that position for a very long time, if at all. I mean, a service user is only a service user once they've had a reasonable grounds decision in their favour.
Yes, of course.
So-
He's a service
But
user.
he has.
He is a service user.
Yes,
Yes,
yes, he is.
yes.
And so it would happen, in some cases, and JB's was one of them, that somebody would be a service user before he became a service user who was in receipt of subsistence payments through the service. That should only have been a very short-term situation, but they were given the £35 payment on the basis of the plain inherent implicit intention of the policy.
I mean, why shouldn't a service user accommodated by the authority, but not receiving subsistence payment through that service, not receive the £65 without a deduction? Isn't that the logical? If you're right that there is a lacuna and he's in a category that doesn't fall into this table,
Yes.
why shouldn't he receive the whole £65?
Because he's in the same position as a service user in catered accommodation provided by the contractor. And you see that that's the first category, and they get £35 to recognise the fact that the essential living needs are provided as part and parcel of the accommodation. So somebody who hasn't claimed asylum is a service user who's provided with catered accommodation by the Salvation Army gets £35. And in practice, if they were a service user in catered accommodation provided by the authority rather than the contractor, they were also receiving £35. So the recovery element, but not the essential living needs element. To read it otherwise...
So the way you've always put this in your grounds of appeal and in your skeleton argument is that the first position is that JB should be treated as if he was within the first case on a proper interpretation of the policy. But alternatively, that if he cannot be treated in that way, and he simply falls through a gap in the policy, he should receive the same as if he had been within the first case. Is that the way you put it?
It's not quite the way I put it. I mean, I put it on the basis that there is a lacuna. I can't.
Well, I've just been reading and rereading your grounds of appeal and skeleton argument, in which you put it in two ways. One is that on a proper interpretation of the policy, effectively, he's in the first category. But if that doesn't work, and there is a gap in the policy, it's reasonable to treat him in the same way.
Yes, bearing in mind that we're looking here at the victim care contract, not the policy, which was introduced in March.
All right, but wouldn't a contractor scratching his or her head, this document on page 248, ask question 4 on the frequently asked questions and get the answer that the Secretary of State gives?
Sorry, I've lost my copy of the frequently asked questions now.
It's on page 305, tab...
I have it again, thank you. Well, the answer they got it for was this should be the position for all clients who are also receiving financial support from NAS.
regardless of where they are accommodated.
Yes.
Mm-hmm.
Okay. So if they're not receiving financial support from NAS,
Yes.
they get the 65. Isn't that what that means?
No, I think this is predicated on outreach NAS clients being those who get asylum support in terms of a financial payment.
Mm-hmm.
And if they don't,
Well, if they don't, they're not covered by the contract. They're not covered by this. If anything, they are other outreach clients who should get £35 per week.
I mean, how on earth there are contractors? Never mind the people they're trying to help. Supposed to make sense of this.
Well, the short
People who,
answer-
let us remember, in the vast majority or a number of cases, English will not be their first language.
No,
And by definition, they're on the verge of destitution
no. I mean, I think the
and
short
victims of potential victims of trafficking and asylum seekers.
The short answer is that everybody in catered accommodation who wasn't receiving essential living payments, they were receiving fully catered accommodation, was getting £35 a week, irrespective of whether the person who provided that accommodation was the Salvation Army or a contracted accommodation provider under the asylum scheme. So all those in fully catered accommodation were treated the same.
I mean, it seems to me that perhaps your best point, but a point to be made, we're giving you a hard time, a point to be made is that if there was a lacuna here, it was so tiny that its significance wasn't realised until the pandemic. And then the pandemic came along and, as in so many things, put a lot of people in a strange position which they never thought they would be in.
Well, look, that is precisely what happened.
That's
in practice.
that's really
Yes.
what your case is, isn't it?
Yeah.
But you're stuck with the language, aren't you?
Well, I accept the language is unclear at best. We'd say there is a plain lacuna, both in the victim care contract, in the FAQs, and in the guidance, which is that there's no express provision for people who are in fully catered asylum support and not receiving payments. But that when you look at the purpose of the guidance, of the contract, of the scheme as a whole, the purpose was to make sure that people got recovery payments, the recovery element of the victim support payment, irrespective of who was providing their essential living needs, whether.
So the purpose becomes more important interpretation in light of the pandemic than it would have been in the de minimis situations which arose pre-pandemic.
Yes, it didn't seem to be problematic in the de minimis situation because they got the recovery payment.
You wouldn't be here arguing about it.
Yes. It became important in the pandemic because of people spending lengthy periods of time and then being given some cash payments. So they fell within the strict language of the policy. What's key to my submissions is an understanding that the purpose of the arrangements under the victim care contract and then subsequently under the guidance was to make sure that asylum seekers who are being supported by the Secretary of State got their top-up recovery payment. The intention was never to provide them with double the amount of living support. And if that's taken as the starting point, that you give this a purposive interpretation, then that leads, we say, inexorably to the conclusion that they could not have provided, because of the payment of a modest £3 sum, to become eligible for £65 a week minus £3.
Well, I understand the logic of what you're saying. I'm just going back to what we were discussing 20 minutes ago. It seems to me it can't possibly depend on whether in September a decision was made that people should have been paid £3 and then later £7.75 in cash. That if the decision had been in September, well, it's too bad, these people have to make do with nothing. Well, they have made do with nothing, but we're not going to make any retrospective payments. That seems to me cannot produce a different result from the result that is produced, given the decision to make that retrospective payment.
They've referred in the skeleton argument to the Inco Europe case.
Yes,
I don't know if the court's had an opportunity to look at that at all.
it's quite familiar territory. But tell us what you say it shows.
So that was a case that was concerned, as the court may recall, with amendments to the provision for rights of appeal in respect of arbitration. So it's legislation rather than guidance. Supplementary is where it is. But it's the approach that the court took to statutory interpretation there that I pray in. And it's at tab 5 of the authorities bundle. It's a very short judgment. We say an important one. So it's a House of Lords decision from 2000. The context of the appeal is set out by Lord Nichols, starting at the bottom of page 82. Going over to page 83 at letter F. And on a literal reading of the relevant provisions as amended, there was no longer an appeal to the Court of Appeal. And on the plain words of the Act, as Lord Nichols says at the beginning of the paragraph that starts between letters F and G on page 83, if the provision, the statutory provision, was read literally and in isolation, the argument was unanswerable. If literally, plainly meant there was no appeal. If we turn over leaf, page 84, between letters C and D, we see how the House of Lords approached the matter. In the paragraph beginning the words, in my view, they said this was a homonodded case. What the legislation was seeking to do, but on a literal reading of the language failed to achieve, was plain. The starting point in those circumstances was to consider the purpose.
And the guts of this case is a quite famous passage of Lord Nichols' speech on
Page 87.
Law Report, page 87.
Yes, exactly.
And the court must be able to correct obvious drafting errors, but plain cases of drafting mistakes, and the court has to be absolutely sure of three things as set out at F to G, and that's the heart of it, isn't it?
It is absolutely the heart of it, and we say that all three of those criteria are satisfied here. And we're looking here at guidance, not legislation. You know, and I make the point again, legislation is drafted in a much more careful way. It's scrutinised much more closely, and yet errors still happen. If you are with me that the purpose of the victim care contract and the guidance is abundantly clear, and it is as stated by this court, by Mr. Lord Justice Underhill, to ensure that people get the recovery element, but not to give them double the essential living needs, the court can be satisfied of the substance of what the contract and the guidance would have provided. You don't need to be sure of the language that would have been used, but you can be sure of the substance of what would have been provided. And that is that people in receipt of asylum support would get £65 minus the value of the essential living needs to which they're entitled under the asylum support scheme. And we know what the value of the essential living needs element was, even if they were getting it in kind rather than in cash, because it's specified in the asylum support regulations at every stage.
And you say, what, it's £30, or was then?
I say it's the amounts set out at footnote 1 to the agreed chronology that we went to right at the beginning. So £37.75 pre-pandemic, then up to £39.60. And currently £40.85.
And you say there should be a in the table on 248 a fifth line. Service user accommodated by the authority but not in receipt of subsistence payments through that service, £35.
Yeah, either that, or it could be by reference to whose essential living needs are met by the asylum support system. There are a number of different ways it could be done.
Well, I mean, you've taken us to what Lord Nichols said.
Yeah, you need to be satisfied of the substance, not necessarily the way it would have been done. What's probably worth looking at is the provision that was made.
Not necessarily the precise words. This is a table designed to help the poor contract providers.
Yeah. But as I say,
With a quick and easy user's guide to how much they're going to give these individuals.
yeah. But it had a gap in it. And the gap was filled in version 1.02 of the statutory guidance.
Right. Well,
Because instead of by reference to the financial payments made, the reference was the current essential living rate. So it's the same whether you're getting it in cash or in kind. So you get the £65 now. We haven't looked at that yet, but it's in the core bundle at pages 221 to 222. So it wasn't, once the error or lacuna was pointed out, it wasn't difficult to remedy it and put everybody on an equal footing. And that's paragraph 15.37 as amended after this was alighted upon problem. If we pick it up 2 lines from the bottom of page 221, generally support to cover essential living needs is provided through a payment of £39.60 per week, but in some cases essential living needs are met through in-kind assistance or a combination of in-kind assistance and payment. A further payment will be made from the VCC, Victim Care Contract, of £25.40, calculated as £65 per week, minus the current essential living rate of £39.60 provided by asylum support to assist with their social, psychological and physical recovery from exploitation. So everybody gets an essential living needs payment and the recovery payment on top of it. Because a literal interpretation of the FAQs, interpreting them against me, would lead to plain inequalities in the treatment of individuals, depending on whether their fully catered accommodation is provided by the Salvation Army or by NAS. It's never been any doubt that those who are in NAS, in Salvation Army fully catered accommodation, get a reduced payment to take into account the fact their essential living needs are met by the provision of full catering, food, toiletries, etc. So the big difference between versions 1 and 1.01 is that the first two refer to payments, financial support, whereas the later version refers to the essential living rate, which is what it should have said throughout.
That's 102, the one you've just shown us.
Yeah.
Page 221. Yeah.
And that achieves the purpose,
Yeah.
as I say, to make sure that everybody gets their additional recovery payment, but people don't get twice the essential living payment.
But it isn't what the previous version said.
No, it's certainly not what the previous version said. No, I mean the previous version is, we've seen, I mean, no criticism of the person who drafted it, it's very clumsily put together, and there just didn't seem to have been an appreciation that sometimes essential living needs were met in kind rather than by way of a financial payment. And of course, as we've seen, there wouldn't have been a significant problem pre-pandemic because people weren't spending months in fully catered accommodation.
No, but what we were told earlier, 4 to 6 weeks was quite commonplace. It's not entirely daily.
No, but it wasn't that they didn't receive anything at that stage. They were treated throughout as getting entitled to the £35, which was given to the Salvation Army fully catered and to outreach clients at the start of the period under version 1.
Ms. Giovanetti, can you see if you have the answer to the question we asked about numbers?
Numbers. Find out. Oh. I'm told that there is an answer, but it will need to be explained to me because it's not straightforward. So, I mean, we're plainly going to go into the afternoon, unless you're not going to call upon Mr. Butler, in which case maybe I could take instructions now.
Well, could you take instructions? We'll just rise for a moment. So I don't want this left hanging in the air. We would like to know what the scale of the problem is.
All rise. Just to let you know that this live stream will continue at its own.
I'll go outside then and take instructions if that's okay.
I think they just arisen for a short period, so just stay. Yeah, it's only if it's a longer period of time that you know, I would have to switch the live streaming off.
the answer.
63 people max in JB's specific position. That there are another cohort who are challenging the policy change in August. That's you again, isn't it? Isn't it?
No,
How did you miss out on that?
Just discussing it, I was just thinking there's a really good point to be taken. I won't tell you what it is, but it's probably the point that's been taken by other people.
Council, are we ready?
Yes.
I'll inform you. Court rise.
Yes, Mr. Chairman.
So I'm told that there's a maximum of 63 people in JB's specific position.
Yes.
Although there's another cohort challenging the policy change in August, and I think those proceedings have been stayed pending this. And as I said at the outset, it's anticipated that other points will be taken about disparities in the event that this appeal is dismissed because of the different outcomes between, for example, people in fully catered Salvation Army accommodation and people in fully catered asylum accommodation. So I think the last point I was going to cover...
Sorry, was there a number for the cohort who are complaining about the August?
No.
But you're worried, Secretary,
My client.
there is a concern that this may open up challenges to the wider challenges,
Yes.
which
Yes. Yeah.
you're perhaps unknowns as far as you're concerned.
But one sees the potential for it. I know Mr. Buxton does because he's been discussing that. But there are points there, obviously, to be taken if there is. If the outcome is that people in fully catered accommodation who receive a modest cash payment also get.
I see. Are you concerned that if this appeal is dismissed, so people in JB's category get this, what you categorise as double payment, that people who were service users in catered accommodation provided by the contractor may say they've been treated unfairly and should be entitled to what you categorise as a double payment as well?
Yes.
Is that the point?
Yeah. Well, given it was the Secretary of State's position from the outset and at first instance that that the interpretation, which in the end the judge preferred, led to an unfair outcome for those two cohorts. Yes.
All right.
And then the final area I was going to cover in my submissions was errors in the judgment below.
Yes.
So, just picking up this, it's a short judgment, and I respectfully say it's a very clear one. Picking it up, it starts at, in the core bundle at page 103.
Yes.
And we say the judge fell into error at page 113. At paragraphs 30 and 31. Having set out the literal meaning of the policy.
Well, you challenged 29, of course.
Yes, yes. At 29, the judge said no ambiguity, no lacuna, and obviously that's the opposite to our case. We say there is both ambiguity and a lacuna. But having said, then he goes on to say the policy is clear and explains what he says the effect of it is. And then at 30...
But there's nothing you quarrel with until we get to 29.
I think our criticism certainly focus on 29 to 31.
Yes.
And insofar as anything in the earlier paragraphs feeds into that or contributes to that analysis, it's summed up in those paragraphs, the error of law that we identify. So at 30, he says the person or persons who drafted 15.37 either intended it to be interpreted in that way, as in any way any cash payment became entitled to £65 a week minus the payment, or they had in mind what generally happened. They anticipated and expected that potential victims or victims who were also asylum seekers or failed asylum seekers receiving financial support under the IAA would be in self-catering accommodation. That's consistent with Ms. Tan's evidence and that of Mr. Ryder, as they both record what generally happened. Notwithstanding what was in the mind of the person or persons drafting version 1.01, the policy as drafted doesn't reflect the consensus referred to. The defendant may have hoped or expected that's what the drafting stated or should state, but it does not. He then goes on to say there's a very good reason why a policy should be interpreted in the way set out in Raisi Mahad, so that persons to whom the policy applies can understand the policy from the document itself. If, because of the way a document has been drafted, it becomes clear to the defendant that the policy is not being implemented in the way the defendant intended, the solutions to change the policy. As stated above, the defendant did change the policy, and the claimant accepts from the date of that change he's not entitled to the additional payment. And then he goes on to deal with the fairness point. We say it was quite plain what the drafters had in mind, and they did have in mind, as the judge says there, what generally happened. Potential victims who are also asylum seekers receiving financial support would be in self-catering accommodation, and they would get the entire sum.
One puts oneself in the position of a hypothetical claimant in this situation, not talking about JB, but one has a number of policy documents which fairly plainly say you're entitled to X. Surely the point of Raisi and Mahad is one's entitled to organise one's affairs on the basis that you're entitled to X. And that if there's an error in that, you can't simply take it back, because people are entitled to live their lives on the basis of what authorities tell them. I mean, how does that important principle find its way into your submissions to us?
Well, if one takes that to its logical conclusion, one would never adopt a purposive approach.
But surely the sort of INCO approach to this is that the mistake must be so obvious that it would be obvious to the claimant that he shouldn't be living his life on the basis that he is entitled to X. I don't mean this claimant, but a claimant.
Well, in my respectful submission, it would have been pretty obvious, because people in JB's position were getting £35 a week in the period prior to the pandemic, and it would have been surprising in my submission if, because, for example, we referred earlier to accommodation providers in fully catered accommodation. Sometimes, for example, not having toothpaste or shampoo, giving people a small payment instead so they could buy their own. It would be a surprising outcome if the receipt of that cash payment to go and buy toothpaste or shampoo also led to a doubling of your victim support payment. It would be such a startling outcome that one might think there would at least be a big question mark over it. So one can imagine that somebody might look at the policy and say, well, if their English is good enough, on a literal reading of this policy, I now receive cash payments, so I must be entitled to more trafficking support. But it would be surprising. It is a surprising outcome.
So pre-pandemic, somebody in JB's position would have received £37.75 a week.
No. Pre-pandemic, depends when you're looking at his position.
Yes.
So pre-pandemic, somebody in JB's position, as in somebody in fully catered accommodation, would not have received any financial support.
Right.
Generally, the general position would have been that they didn't fall within the literal words of the policy because they wouldn't have been receiving financial support. They would have been receiving essential living support, but they'd have been receiving it in kind. So they'd have got the £35 that's given to all other victims who are in fully catered accommodation. I mean, just look at the anomalies a little bit more. The effects of judges' reading and the JB's reading is that you have two people in JB's position in hotels on the same road, and one hotelier provides 3 meals a day and toiletries.
And the other, you're self-catering. No, we understand that.
No, sorry, I wasn't going to say self-catering.
Oh, right.
I was going to say the hotel next door runs out of toiletries and says, well, I'm going to give people, instead of they can't have their, we can't provide them with toiletries, so we're going to give them £2 a week to go and buy toothpaste or shampoo. The person who's provided with the £2 a week also gets double the victim support as a victim of trafficking, as compared to his neighbour who gets everything provided and gets no financial payment at all. And that's so anomalous as to be plainly, we say, absurd. It could not have been what any sensible decision maker writing a policy could have intended. So we're firmly within Inco-Europe territory, my respectful submission. And I'm not just plucking that out of the air because that was the example given in the evidence that some providers couldn't provide toiletries and so gave people the money to go and buy their own. Some didn't, some provided everything in kind. So there was no financial payment in fully catered hotels. I don't think there's anything else that I was planning to address, but I'd just briefly ask Mr. Toman if he thinks
Of course, yes.
Unless my lords have any questions.
No, thank you. No. Mr. Toman?
Nothing from me, thank you.
Thank you very much. Well, we'll break off here till break off now till 5 to 2. Mr. Ovanetti, Mr. Toman, I'm not encouraging you, but if you come back at 5 to 2 and say there is a point lasting no more than 5 minutes, which you would have made had you thought of it, then of course, feel free, and after
Very
that,
kind indeed. Thank you
we'll
very
hear
much.
from Mr. Potter.
All rise.